Sir, with your permission, shall I start, sir?
Please, sir. Please.
Thank you, sir. Ladies and gentlemen, welcome to the last day of the Private Limited Companies on Companies Act 2013, part 2, last day. That is a bonus session for you. Thanks to the resource person for accepting the same. Even though it is a hectic schedule, on their hectic schedule also, he has taken much of our time and seeing that every point is to be clarified. Thank you, sir. Thank you very much. Without wasting much of your time and the time of the delegates, I hand over the proceedings to you, sir. Thank you, and over to you.
Thank you very much, sir. Respected Chairman, Vijayawada branch. It is my privilege to have received this great opportunity to address the August gathering of chartered accountants, not only in Vijayawada, elsewhere from South India also. So we will now finish off the balance areas. Continuing the discussion. Yesterday I finished inspection and investigation. We'll now go into oppression and mismanagement. Oppression and mismanagement. Unfortunately, in the Companies Act, they have not defined what is an oppression, not possible to define also. But the Supreme Court in the Kalinga Tubes Limited case made an attempt to define what is an oppression. The Supreme Court said the conduct complained of, the conduct of the company, the conduct complained of is the lowest involving visible departure from the standards of fair play and fair dealing on which every investor has relied upon when he invests the money in the company. Beautiful definition. What the Supreme Court says is, how can an ordinary member of the company fight with the might of the body corporate or a company? How can an ordinary shareholder of Reliance Industries Limited fight with the Reliance Industries Limited? If the behavior of the company is so bad, what kind of behavior they are not able to define? Such a wretched behavior. They never expected the company to behave in this manner with the members. Every member has invested in the company based on certain guarantees given to him under the Companies Act. I know I am just holding 100 shares. I don't expect the management of the company. At the same time, the Companies Act has guaranteed certain rights to me. They are basic rights. They are fundamental rights as far as I am concerned. If those rights are violated by the board of directors, by the company, by the officers of the company, it is oppression. The conduct complained of is the lowest, involving visible departure from the standards of fair play and fair dealing. There's something called fair play, fair dealing, on which every member entitled to rely upon to invest when he invests the money in the company. I'll practically tell an example. Let us say you have a shareholder holding 100 shares in the company, entered the registered office of, say, so just for the fun of it, entered the registered office of Reliance Industries Limited, and they did not allow him inside. Somehow he jumped the gate, went inside, went into the company secretary's room and told him, "Good morning, sir. Sir, I'm the member of your company." Hey, very good, fine. Sir, I'm not received the annual report. Oh, I see. How many shares you are holding? Sir, 100 shares. What? Holding 100 shares in the company, you got the audacity to enter my cabin and ask me? Sir, where is audacity involved? Sir, I am the shareholder. Now, the company secretary, say for the fun of it, of Reliance tells you, "Hey, Chaukidar, isko aise utha ke bahar fek do yaar. Just lift him physically and throw him out." What is this behavior? Somehow this fellow, what he did, there was an annual report on the table, he grabbed it. And before the Chaukidar could come, he jumped the compound wall, jumped the gates and went away. Then, when the AGM was conducted, he came to attend the AGM, the Chaukidar did not allow inside. He was a jumper, again he jumped, came inside the hall. Then he went to the restaurant section to have some tiffin. They gave chutney and sambar. They refused to give him idlis. Then he went to the main hall. He was not allowed inside. He was not allowed to participate in the meeting. He was not counted for quorum. He was again chased and thrown out. He went away. Again, he came to inspect the minutes of the meeting. He was not allowed. So the behavior of the company was to harass the member. It is not an isolated action. It is a continuous action. This is oppression. How can an ant fight with the might of the elephant? It's like that. Reliance Industries Limited, what kind of power they enjoy? Money power, muscle power, economic power, political power, managerial power, you name it, they have. How can I am a very small person, an investor, fight with you? I am not a beggar. I am only asking you, demanding the rights given to me under the Companies Act to be followed. If those rights are not given, oppression, that's all. Quickly running through, the term oppression is not defined. Oppression means if it is burdensome, harsh and wrongful. There is an element of probity and fair dealing. Cornering of shares, non-declaration of dividend, they don't amount to oppression because, see, one point we must understand, every pain of the company is not the pain of the shareholder. Okay, they have earned huge profits. They are not declaring dividend. It would affect the shareholder. It is not oppression. Very simple. When your individual rights guaranteed in the Companies Act is violated, it is oppression. I told you the conduct complained of is the lowest, involving visible departure from the standards of fair play and fair dealing, on which every says the conduct should be burdensome. So, and one more point to constitute oppression is the conduct should not be isolated conduct. It was a continuous conduct. It was not just by mistake the conduct. It was very planned, calculated conduct. In my given example, I told you they did not send me the annual report. They did not allow me inside the AGM. They did not allow me to inspect the minutes of the meeting. I can make a consecutive story on that. Then there must be continuous acts. The burden should be wrongful, harsh, and all that. Now, instead of going through this again and again, members may please remember, in order to constitute oppression, three things you have to keep in mind. One, the Companies Act gives you 36 individual rights to you. Right to receive notice of the meeting, right to attend the meeting, right to be counted for quorum, right to vote at the meeting, right to receive dividend when declared, right of right shares, right of bonus shares. The story goes on. If any of your individual rights given to you under the Companies Act, irrespective of the number of shares you hold, is being violated, it is oppression. One more thing, the conduct should be burdensome, harsh, and wrongful. Mens rea need not be proved. Suppose, say, for the fun of it, the shareholder one day went into the room of the company secretary, locked from inside, and lifted the company secretary by collar and said, "Stupid fellow, I had come here 10 times to ask about the registration of transfer in my favor, and every time you are not allowing me inside." Then the company secretary says, sorry, sir, yes, sir, no, sir, please sit down, sir. I'll just look at the computer and tell you. He saw the computer and said, "Sir, we have not received those documents." Hurry, you should have told me 15 days back which post office I will go and verify. And now the company secretary says, "Okay, sir, you are saying that my behavior towards you is harsh and wrongful. Where is mens rea? Where is how will you prove mens rea? Intention to commit the offense. Where is intention? What is the relationship between you and me? You said that I have tortured you. Why will I torture you? Where is the mens rea? Where is motive?" Motive need not be there. This beautiful point. The conduct of the company and the officers of the company was wrong, harsh, burdensome, wrongful. That's enough. Now, to continue this, to answer the motive, some people have a lot of what you say. I'm searching for a correct word. what say, anyway, leave it there. The conduct should be burdensome, harsh, and wrongful. Mens rea need not be proved. Many people have lot of jealousy, we can say. See, I used to tell the students, if I don't get through CA also, no problem. If you don't get through CA, I'm so happy as if I got through CA. That's why our parents, our elders, grandfather, they all used to say, don't tom your achievements. No one in the world is happy with your achievements except your parents, teachers, and other elders. Everyone has got jealousy, vengeance in there. That is how it is. So mens rea need not be proved. And it is not an isolated act. It's a part of consecutive story, not one or two acts. If these three things are there, we can say it is oppression. So very simple. Yeah, ordinary shareholder has invested money in the company. He might have invested only 100 shares, 1,000 rupees, doesn't matter. But he invested based on those 36 rights. A violation of those rights will amount to oppression. And the procedure, how to approach, where to approach, we'll see in oppression. Next. The section says, who can apply for oppression? Company having share capital, 100 members or 1/10 of number of members, whichever is less. So don't fix your mind 100. If the number of shareholders itself is 30, 3 members can file a case for oppression. Then members holding 10% of issued share capital. Not having share capital, 1/5 of the members. But then you have to go to tribunal, company law tribunal. Tribunal may waive off the conditions. These are all new points now. Apart from that, the central government can also file for oppression if the conduct of the company is prejudicial to public interest. Are we running the company in the interest of the members or in the interest of others? Public interest is slowly coming in. So now they have added this. Central government also filed the case under this section in public interest. Now, when you can file the case, what is the allegation? Your conduct of the company is oppressive to members. Just now we discussed what is oppression. Prejudicial to public interest. Prejudicial to the interest of the company. Fourth allegation, material change has taken place in the management of the company. By reason of the material change, it is likely that the affairs will be conducted prejudicial to the interest of the company or the members. Interest of the company or the members. Yesterday, I gave an example regarding this attempted takeover of Reliance, attempted takeover of L&T by Reliance. So what happened there? Then the minister telephoned and told him, hands off L&T. Material change in management is likely to has taken place, and it is likely that you may conduct the affairs of the company prejudicial public interest or the interest of the company or the members. How will you prove? Depends on facts of the case before the tribunal. So these are all the allegations. Now, material change in management means what? Change in the board, change in the ownership, change in the manager, and those cases. Changes in the interest of creditors and debenture holders obviously will not be material change. Now, these are the allegations. Before the tribunal, what has to be proved? First, allegation you prove. Proving the allegation is only one part of the story. Second part of the story also you have to prove is, sir, to wind up the company will unfairly prejudice members. Otherwise, the circumstances justify passing winding up order on just and equitable grounds. What is this? What is this? Sir, the people are fighting like cats and dogs. Given a free charge, please wind up. Sir, don't wind up. Winding up is affecting our interest. See, the disease is the cure is worse than the disease. Sir, don't wind up. Circumstances justify winding up order, don't wind up. Then the tribunal says, what should I do? Pass such orders as it deem fit to bring an end to the matters complained. I'll just tell a case law which I handled it very briefly. There was one land in Hyderabad, I'm not naming it. there was one land in Hyderabad, a old cinema theater. They want to demolish that land and then purchase that land. So the land was some cost of the land those days was some 40 crores something. Two groups of shareholders came together. One Yadav group, one Marwadi group. 50-50 shareholding, 50-50 directors. In India, unfortunately, this 50-50 doesn't work at all. It should always be 51-49. Anyway, these two fellows came together. So there was some disputes among them while investing and all that. So they agreed for first installment, second installment, third installment. Then there was a dispute and all that, heavy dispute. So then these people fought with each other. They went to those days CLB, Company Law Board. So there one group proved that, see, our ASPA against the shareholding agreement, our directors were removed and they appointed their directors. So the main allegation we proved. What was the main allegation? Oppressive to the members. Sir, they did all these things. They affected our rights. Second, what we have to prove, sir, wind up the company. These two groups are fighting like cats and dogs. Wind up the company. Third, what you have to prove, sir, don't wind up. If you wind up, then we'll be affected. Then what kind of orders will be passed? Such orders as to deem fit to bring an end to the matters concerned. So every time winding up is not a solution. In that case, what they did, they compulsorily asked this Yadav group to hand over the shares to the Marwadi group because they have indulged in all wrong practices. And they asked them, you continue the management and all that. That kind of orders can be given. So this is the idea behind oppression. So any orders the tribunal can pass. Generally, what kind of orders they'll pass? Regulating the conduct of companies' affairs in future. You had three groups of shareholders. You're all fighting with each other. We cannot wind up the company. Better do one thing. A group and B group both together will take away the shares of the C group, and A group and B group will do joint management. Purchase the shares from other members. That's what I told you. Consequent to purchase, reduction of capital. Suppose each group does not have money to purchase the other shares. Let us go for reduction of capital if that is the solution. Then termination or modification of agreements between MD, manager, director. Terminate, throw that termination of any other agreement, setting aside the sale of property, constituting advisory body. So these are all some kind of orders which can be passed. Any orders the tribunal can pass. This is all about oppression. Then, now what they have done, they have amended the Companies Act quite recently, about just 1 year back, and government also has powers. So far, who can apply for oppression? Only those members and all. Now, government also can apply under this section in these circumstances. When a person concerned with the conduct and management is guilty of fraud, misfeasance, negligence, or breach of trust, or business is conducted by persons not in accordance with sound business principles or prudent commercial practices. There's no intention to earn profits, or they are conducting likely to cause serious damage industry to trade, industry and commerce and business. They are indulging in undercutting. They are destroying the whole industry. Or the business is managed to defraud the creditors, members and other purpose or fraudulent purpose. So they have empowered the power. So the government can go to tribunal and get an order. Sir, whether this person is a fit and proper person to hold the office of director or any other office conducted the management. So the tribunal will go through the behavior of that officer and record the decision. And once the tribunal is satisfied, they will throw out this director and any person from office for a period of 5 years. So this is one extraordinary section now included in operational mismanagement. And of course, after 2 years, 3 years, maybe the tribunal may review his conduct also and take him back. Then if he happens to be managing director or time director, he will not get entitled any compensation for loss of office. So based on certain case laws, I just made out some examples. What is oppression? What is not an oppression? Bona fide exercise of powers, it's not at all an oppression. After all, powers means discretion. Shareholders may not like, but the officers of the company, board of directors, management may do the powers. That's why I told you every pain of the company is not the pain of the shareholder. Then illegal allotment, where majority is reduced to minority. Yes, it is oppression. How it will happen? Suppose, let us say, two groups of shareholders are there, 50-50 shareholding, and they each is holding, say, 6 directors, 6 directors. So one particular board meeting, one group, 4 directors did not come. So taking advantage of the situation, the other group allotted the shares only to themselves, thereby tilted the majority. Oppression. Then termination of distributorship. Hey, listen, the relationship between board of directors and shareholders is not the principal agent relationship or trustee beneficiary relationship. Shareholders cannot interfere in the management. Shareholders can interfere in the management only consistent with the Companies Act. So therefore, day-to-day management vested with the board of directors. Shareholders cannot interfere in that. So this is not oppression. Then it's not sending the notice. Yes, violation of rights, it is oppression. Unwise act of the director. No, it's not an oppression. You can throw out a director. Non-declaration of dividend, not an oppression. Then increase in share capital. You may not have money. That doesn't mean anything. It's not oppression. Acquisition of shares. Huh? It's a democratic world. Anyone can purchase the shares. No, sir, he's trying to take over the management. Yes, permitted. You follow the rule of law. The concept of free lunch has gone. So these are giving shorter notice without complying with the provisions of the Act is very much oppression. Attempt to force more risky object. Yes, it is all oppression in the sense that the Companies Act provisions were not followed. Special resolution was not passed and all. It is an oppression. Non-calling the general meeting, it is an oppression. Very simply, our rights have been violated. My basic rights given to me under the Companies Act is violated. It is all oppression. Non-maintaining the statutory records. After all, I want to inspect the rest of members, rest of directors. They are not there. Oppression. What is mismanagement? These are not mismanagement. Violation of conditions of memorandum, they are all mismanagement. You don't follow the memorandum, you don't follow the articles, selling the assets without complying with the provisions. Just looking at it, we can easily find out. Unwise act, these are all mismanagements. And diversion of funds, non-allowing the directors to function, Gundaism, Dadaism. If the shares are allotted to one group, taking advantage, these are all mismanagement, diversion of funds, all those things. Then advances and loans, not complying with the provisions of the Companies Act, infighting among directors. These are all classical cases of mismanagement. Now, class action suits. Section 245 is a new section which is introduced in the Companies Act. On the day, I made a passing reference. Now, because of the legal entity concept, outsiders, particularly outsiders, the members, the deposit holders, or any affected party, cannot directly sue the directors, the auditors, the consultant, and other people because of the legal entity. What does it mean? These people, even if they are affected because of the fraud performed by all these people, they have to sue the company, and company will turn sue these people because of the corporate veil. In class action suits, that corporate veil is lifted. The corporate veil is lifted. Now these people can directly sue the auditors, the consultants, the directors, and other people. That is called class action suits. Who can apply? 100 members or 5% of the members in case of company having share capital. But in case of listed company, members holding not less than 5% of the share capital in case of unlisted company, and 2% of the issued capital in case of listed company. And 1/5 of the total number of members in case of not having share capital. The calls has to be paid. Deposit holders also can apply. On the day I told you, 100 deposit holders or 5% of deposit holders, or people holding 5% of the value, they can apply. What they have to prove? What they have to prove? Hey, they have run the company opposite to members, prejudicial to public interest, prejudicial to the interest of the company. All that you have to prove. And then finally, you can sue and get damages for whom? From the company and its director for fraudulent unlawful conduct, audit and the auditor's firm. This I told you in audit also. Then for, see, audit firm, you can sue for misleading statement or particulars. Then you can sue for fraudulent, unlawful, wrongful act or conduct. Expert advisors, consultants also, you can sue all this. So now, apart from suing you for compensation and damages, now one example I'll tell you, this in Satyam Computers fraud, I've been telling you, LIC alone lost 1,000 crores. LIC shareholder, the market value, they lost it. Now, if this class action suits had been there, I'm not exaggerating, for entire 1,000 crores loss, they could have directly sued PwC and also those two auditors, if class action suits had been there now. So all the members, the deposit holders, those specified people can sue the auditor directly for misleading statements and all that. Apart from that, what other relief they will get? Restrain the company from committing ultra-virus. I can get a restraint order, stay order in the court. Sir, is this board of directors are going against the memorandum articles, injunction suits I can get. Then committing breach of provisions, I can get injunction on that. Then, sir, they passed a resolution altering the memorandum and articles and suppression of material facts. See, in the explanatory statement, they did not give me full details. They got the resolution passed. This is the ulterior motive. Come on, they can go to the tribunal and get it. These things suspended. Then restrain the directors from acting on such resolution. Restraining doing any act contrary to the provisions of the act or any law. Restraint acting actions, any resolution passed by the members, such other remedy. These kind of remedies also can be given. And please see the penalty. If you violate the provisions of class action suits, the tribunal order, if the company fails to comply with the tribunal order, fine. Minimum 5 lakhs to 25 lakhs. Every officer in default, imprisonment to 3 years and fine 25,000 to 1 lakh. This was in brief about class action suits. Of course, if you file any frivolous complaint, just destroying the goodwill of the company and all that, then the person making the frivolous, vexatious complaints will be fined up to 1 lakh rupees. So this was a brief discussion on operational mismanagement and class action suits. Now, it's very much understandable that I cannot discuss everything in detail because these are all separate topics by itself. And we don't do it on daily basis as such. So the idea, as I already discussed with the chairman, the idea is only to have an overall understanding of the subject. Next, compromise and arrangements. Many of us have not understood. Procedure for compromise arrangement is there in the book. We can always follow. That is not the issue. We are not writing the examination here. I will focus more on why do we require compromises? Why do we require arrangements? I'll spend some time on this. First, I will take a very practical example. I have a lot of knowledge about the cement industry. I'll take the cement industry as an example and start. I remember in early up to 1991-92, in the last 50-60 years, up to 1991-92, there were continuous cement shortages in the country. Cement and steel are infrastructure industries. Without cement and steel, there's nothing we can do. And many of the politicians in South India have come up in life only black marketing cement. Keep it aside. Just as a passing reference, I told you. Fine. So, and at those days, technology for the cement was also very poor. The cost of production was very high. The number of cement units in the country were very less. See, the figures are not correct. There's only for understanding purpose. Let us say all big plants, small plants, all put together, about 1,000 cement units were there. Something different happened in 1992. The government announced the cement policy. Many things happened at a time within a year. The government announced the cement policy. Then the licenses were given, registrations were done. They suddenly and they allowed more than 5,000-6,000 cement units to come at a time. All of them came. I remember more than 1.5 lakh crores investment came into the cement industry. All of a sudden, unexpected investment, more than 1.5 lakh crores. Then at that time, the technology for cement started changing. From the wet process technology, dry process, rotary technology also came up. Mini cement plants became viable. Previously, only 350 tons per day was viable, but then thereafter, about 150, 200 tons also became viable. All these things happened, and exports for cement also became viable. Wonderful. Now, after a gestation period of 1-2 years, all these companies came for cement manufacturing, say in 93, 94. In 95, 96, the scenario was totally different. The supply of cement was far in excess of demand. See, demand will increase only at a constant rate. Demand all of a sudden will not increase. So the supply of cement was more than demand. More than demand. So as a result, what happened? The prices of cement came down. I will tell you at one point of time, cement is packed in 50 kgs bag. The marginal cost of cement those days was say around 92 rupees. The selling price of cement came down as low as 88 rupees and 90 rupees. Companies could not recover their marginal cost also. Forget your contribution, forget your profitability as well as fixed cost recovery. This was the position sometime in 1996, 97, let us say. Then what happened? All the 5,000 factories without exception were incurring losses. Whether it is Andhra Cements, whether it is Panyam Cements, whether it is Rasi Cements or any cement company, Tata Cements or Birla Cement, everyone was incurring losses. If you sell the cement at less than the marginal cost, there is a question of you sustaining and surviving. Everyone was incurring losses. If you look at 1995 balance sheets of all the cement companies, all the net worth was eroded. This situation went for 1.5 years. Sick is sickening. Sick is sickening. That's all. Defaults everywhere. Defaults everywhere. Look at the scenario. The best of the best companies, come on, they defaulted in the payment of interest and repayment to banks, financial institutions. They defaulted the repayment of interest and principal to debentures. They did not pay dividends to preferred shareholders. Then forget equity dividends to the equity shareholders. Then employees' dues, statutory dues was not paid. Government taxes and all was not paid. Sick is sickening. But this is industry. Industry operates in cycles. Prosperity, recession, depression, prosperity, recession, depression. Then all of a sudden, sometime in 97, 98, suddenly there was some monopoly and all that, keep it aside. Suddenly the prices of cement went up. Somewhere around from, I'm not sure of the figures, just understanding purpose, say somewhere around from 90 rupees per bag to 125 rupees per bag. 40-50% is jumped to overnight. There was some oligopoly contract and all, few monopolies, they control the market. Keep it aside. The government was stunned everywhere. And one more thing, you see, when it is a loss-making company, if the shareholders put pressure on the board of directors, they will wind up. It is not their fault. Winding up is not a solution, please understand. Now, what is the present position? Because of the industry, everyone is incurring losses and all defaults everywhere. If the pressure is put on the board of directors, they'll wind up. Winding up is not a solution. Who will purchase the industry here? As I told you, the cure is worse than disease there. Now, suddenly the prices went up. I see a ray of hope at the end of the tunnel. Industry is now reviving. Wonderful. Now, what is your problem? Come on. You start improving the manufacture and then sell in the market. The issue is paisa ho paisa, working capital, further term loans. Now I have to repay. With this balance sheet, if you go to the bank or financial institution where everything is loss showing, they'll throw you out. The chowkidar also will not allow you inside. So first and foremost thing what you have to do is eliminate losses from the balance sheet. This is the structure, basic idea, let us understand. Eliminate losses from the balance sheet. How? Internal reconstruction. Compromise. In accounts, you do internal reconstruction. What do? You ask for sacrifices. Call the debenture holders, call the equity shareholders, call the creditors, call the bank's financial institution sacrifices. And using that money from the capital reduction account, you used to write off the losses, preliminary expenses, unabsorbed depreciation, unprovided depreciation, and reorient the balance sheet. With this reoriented balance sheet, you go for further term loan working capital. This results in compromise arrangement. This is the background you must know. So, compromise presupposes existence of dispute between the company and members, company and creditors. There is a dispute regarding what? Rights and liabilities. Rights and liabilities. Debenture holder says, my dues are there. Creditor says, my dues are there. Bank's financial institution dues are there. There is a liability between company and members, company and creditors in relation to their rights and liabilities. Settlement of this is called compromise by mutual concessions. Settlement of this dispute between the company and creditors and members by mutual concessions is called compromise. Concession has to be given by the other party, not by the company. It is called compromise. And so they should be empowered. On the arrangement, the word arrangement means the dispute is yet to come. Even before the dispute has come, we reorient the rights and liabilities. That's called arrangement. That's all. So look at the whole scenario together. Once again, I'll bring it together. Industry is not doing well. It is not my mistake. Business operates in dynamic environment. So now we are in recession period. We are in depression period. Industry is not doing well. Everything is sick. Liabilities are pouring anything. Now, winding up is not a solution. Winding up is not at all a solution. I see a ray of hope at the end of the tunnel. Now, I want to reorient my balance sheet. If I want further working capital, term loans and other finances, I have to eliminate losses from the balance sheet by reorienting my balance sheet through compromise and arrangement. That is the idea. That is the idea. So all this I've explained to you. Now, what is the procedure for compromise arrangement? Quickly, I'll run through. First, come on, prepare a scheme. Just now I told you the compromise arrangement in just 5 minutes. It is not so. You have to prepare a complete project report of about 40-50 pages. What is the present position? What are the problems the company is facing? Then what is the ray of, what are all the problems? What is the ray of hope I see at the end of the tunnel? So what are the sacrifices required? Projected balance sheet for the next 5-6 years. How I can revive the company? It is nothing but revival of a sick company and infusing more funds through sacrifices. That is the idea behind compromise. So prepare a scheme between all that and take the approval of the financial institution and all. Board meeting. So finalize the board meeting and inform the stock exchange. Now comes the point. Members' approval is required. Who conducts the meeting usually? Board of directors will conduct. No. If board of directors conduct the meeting, they can manipulate. So tribunal will conduct the members' meeting and creditors' meeting. Tribunal means the tribunal will appoint the chairman and he will give the report. That's all. In fact, more manipulation takes place there only. Anyway, this is not my area of discussion. So tribunal will convene the meeting and give the notices and all that. Then it should be approved by the members and creditors. Please listen very carefully. Usually we hold a separate meetings. Equity shareholder, preference shareholder, debentures, whoever is involved in sacrifice will ask for the meeting. It should be approved by 3/4 in value of the members and creditors representing majority number. It should be approved by 3/4 in value. Those attending the meeting, 3/4 in value, 75%, and that 75% in value should constitute 51% in majority. So separate meetings are held. And once this approval is there, again, then you have to file a petition with the tribunal in the respective forms and all that. And all material, you have to file affidavits and other things. Of course, now they have amended and say, who can object at the tribunal? Only not individual shareholders. Shareholders holding 10% of the shares are debt outstanding 5% as per the latest audited balance sheet, then only they can make an objection before the tribunal. Then the tribunal will approve the revised scheme and they will ensure the statutory provisions are complied with, the meeting has duly passed, majority, it is the benefit of the company as a whole, it will protect the interest of shareholders, the scheme is workable, feasible, all the tribunal will ensure they're not against public policy, all that. Then they'll take a certificate from the auditor. Then the tribunal may sanction the scheme and they will provide for all the matters, taking everyone's rights into account. Then the tribunal scheme shall be filed with ROC. Now, the tribunal's role does not come to an end the moment they approve the scheme. The tribunal will play a proactive role. What is the proactive role? First, after the scheme is sanctioned, the tribunal will supervise the scheme. You have to file periodical reports to the tribunal, whether as per the game it is really working out or not. Sometimes, sir, I want some modifications. Every time we cannot convene the meeting of the members and creditors. So tribunal will have powers to modify the scheme and make changes in the scheme. And finally, if it works out very well, excellent. Otherwise, it's like flogging a dead horse. No point in just pumping money. So they will wind up last resort. So the role of the tribunal is very much more approval of the scheme, modifications of the scheme, supervision of the scheme, and finally, if the scheme is unworkable, they'll go out for winding up of the company. So compromise arrangement is nothing but internal reconstruction. No new company comes into existence. As I told you, the whole game plan we should not miss. The game plan seems to be very simple. The game plan is, in order, I have seen the revival now. As of now, I am a sick company, but I see a ray of hope at the end of the tunnel. I can see the revival now. For revival, I want the members and other creditors to make some sacrifice today so that tomorrow we can all sail together and enjoy the profits. To start a company is so difficult. To create a goodwill, to create infrastructure is goodwill. So the solution is compromise arrangement. Now, we'll now move on to mergers and amalgamations. Let's not move from the game plan. The same game plan. What is the game plan? The game plan is eliminate losses from the balance sheet and further working capital. The same game plan, I can do it with starting a new company, B Limited. A Limited assets and liabilities will be taken over by B Limited. Sir, why do you start external reconstruction in the accounts? So why do you start a new company, sir? One big drawback in compromise arrangement is the same company's assets and liabilities are involved. One great advantage, the problem in the compromise arrangement is same company's assets and liabilities are involved, same company carries on the business. In mergers or amalgamations, the new company may be A new limited, completely new company, or B limited, one of the existing company. So in mergers, what happens? See, the A company's assets and liabilities is taken over by B company. And there'll be a lot of advantages, synergies of operations. For example, A company may have excellent production facilities. They have excellent infrastructure. Cost of production is less. B company has got good marketing network, dealer distribution network, brand names. You got it? There are various reasons why we go for mergers and amalgamations. If you do the whole thing in the same company, it is compromise arrangement. If you do it, the whole game in the new company, either completely new or one of the existing company, B Limited, it is called merger and amalgamation. amalgamations. So assets are merged and all that. Fine. Why do you do this? Sir, why do you start a new company? Lot of expenditure, time and all that to affect economies. Just now, synergies of operation, to avail tax concessions. As a chartered accountant, you know pretty well. A Limited may be a loss-making company. B Limited is a profit-making company. Once you do the merger amalgamation, come on, all the losses, unabsorbed depreciation, everything will be set off against the profits of B Limited. Revive a SIC unit, expand the business, eliminate the competition. Those are all the things. So we may go for mergers and amalgamations. Mergers and amalgamations are controlled under the Companies Act under 6 different sections: 232, 233, 34, 35, 36, 37. We'll start quickly on all this. First, mergers and amalgamation of companies, 232. 99% of the mergers amalgamations is under this category only. 99%. So come on, A Limited's assets and liabilities will be taken over by A New Limited or B Limited. B Limited is already existing, and they will take over the assets and liabilities. The purchase consideration is paid directly to the shareholders of A Limited. Then A Limited is a hollow company. As a part of amalgamation, mergers and amalgamation of 233, A Limited will be dissolved. A Limited will be dissolved. Now, you all know, we did in accounts, that, what is that? Merger, in the name, in the purchase of shares, 2 methods we call it, So automatically, the losses will be eliminated. When you take the assets and liabilities in B Limited, the amalgamation, the nature of purchase, amalgamation, the nature of merger, we had done all the entries. So that way, the losses will be eliminated. So what is the procedure? Same like that of compromise arrangement only. Only thing, same, both the cases it is same. Only thing is, both the companies have to follow the procedure of compromise arrangement. A Limited as well as B Limited has to follow the procedure. So some special points, let me quickly discuss. Transfer of assets and liabilities will take over. But substantial part, if you take over, that's enough. Balance and all, they can directly sell it. It need not be that everything should be taken over. Then this normally called as merger. There is no hard and fast rule. If A Limited is taken over by A New Limited, new company created for the purpose, we call it reconstruction. No hard and fast rule. But usually if it is taken over by B Limited existing company, it's called merger. Reverse merger means normally loss-making company is taken over by profit-making company. Profit-making company taken over by loss-making company is called reverse merger. But from a law point of view, it doesn't make any difference. Same procedure you have to follow. Then what is demerger? Demerger. See, for example, L&T has got 36 undertakings with them. Now, software division, shipping division, construction division, cement division, all they have got. Suppose, let us say they want to separate the software division. So they take out the division and make it L&T Software Limited. That's called as demerger. Usually in family undertakings and all, this demerger usually takes place. Now, as I told you, same procedure of compromise arrangement, but both the companies have to follow the procedure as such. Then voting majority is same. That is 3/4 in value, majority in number. Then some these documents which you circulate for the meetings is slightly different. The documents will be different. Then tribunal order will provide for everything. Now the question is, what happens to the A Limited? Their contracts, litigations, rights and liabilities, everything will be provided in the transfer document which is approved by the tribunal. Everything, allotment of shares. Then what will happen? Once the whole merger amalgamation is completed, then A Limited is a hollow company. You file a petition, it will be dissolved. Not necessary that you to follow separate procedure of dissolution. As a part of merger amalgamation, they'll be dissolved. Then small issues, right? Declaration of compliance you have to give for. Then dissolution as a part of this case. And the tribunal order is enough for everything. Now many issues will arise. What about the now the license are in the name of A Limited? How to get transferred to B Limited? Show the tribunal order. Then go for mutation of land and all that. Then this power connection, electricity connection, utilities, everything is in A name. Show the tribunal order, it will be transferred in B Limited. Similarly, bank accounts will be. So the binding effect of the tribunal order. Services of the workers. Services of the workers will not be automatically transferred to B Limited. It is optional both from the company point of view as well as worker point of view. If the company offers to transfer, fine. If they don't offer, if they offer also, I need not join. So, in fact, 90% of the mergers or amalgamation is only to avoid the old employees in the old company. So, services will not be automatically transferred, and no compensation to managing director. So, these are all the points. So, this 232 compromise the merger amalgamation. Merger means usually there's no hard and fast rule. If the assets and liabilities of one company is involved, it's called merger. If the assets and liabilities of two or more companies are involved, it is called as amalgamation. The other company may be completely new company or one of the existing company. So in the starting this new company or merger, then what will happen? No, we will now the losses are eliminated from the balance sheet, and then we go for further working capital and story goes on. Now 233 fast track route. Same procedure of 232, but only thing here is no tribunals approval. Only the same, come on, the central government itself will approve. Members, once they approve, fast track route. But this will be applicable for whom? Two or more small companies wants to merge or amalgamate. Two or more companies, small companies. On the day we discussed, private company, paid up capital, less than 50 lakhs or turnover less than 2 crores. Two or more small companies are holding to subsidiary, holding to wholly owned subsidiary. You want to merge or amalgamate it, then shortcut method, fast track route 233. So now here what happens? You have to give, before you send the notice, company itself will conduct the meeting and all, but you have to send the notice to registrar of companies. And if it is in liquidation, official liquidator, you have to send. Declaration of solvency. One of the biggest problem is if it is if the assets are the liabilities are more than assets, then you cannot go for the shortcut method. You have to go. So declaration of solvency has to be filed. Then notice, you send the notice, but here all this has to be given, notice of the meeting. Approval of the members. There I said in 232, 75% in value, majority number. Here the scheme should be approved by 90%, members holding 90% of value and creditors holding 90% in value. They must approve it. Then confirmation order will be given by the central government, Department of Corporate Affairs, New Delhi. And you don't have to go to, come on. What? One minute. You don't have to go to tribunal. So the Department of Corporate Affairs, New Delhi, themselves will give the binding up order and all that. Confirmation order. Now there's one more writer. While going through your case, if the central government finds it is not a fit case to pass the order under 233, they may refer the matter back to the tribunal and go through 232 route itself. Then the tribunal will continue. Then filing with ROC. That's all. This is 233. Dissolution of the transfer. Merger amalgamation with foreign company 234. Same procedure of 232 you have to follow, but one of the transferee company can be foreign company also. That is also permitted, either A Limited or B Limited. One extra point is prior approval of RBI will be required, and valuations has to be done by the international valuers. internationally accepted principles of accounting and valuation you have to do. That is one extra point. Otherwise, the procedures are both the same. We will now go to a very interesting case of merger amalgamation 235 by transfer of shares. Amalgamation or merger by transfer of shares 235. Now, 232 was the main section. 233, 234 was supporting only. Right. One of the biggest problems in 232 is time consuming. It takes 2-3 years. Costly, a procedure oriented, various approvals are required, creditors, members approval, tribunal's approval is required. But 235 is very simple. Game plan, don't miss it. Game plan is to eliminate the losses from the balance sheet and take synergies of operation and go ahead and get the further working capital. The same game plan can be achieved in a different way in 235. In 235, what we will do, A limited, B limited. B limited will not touch A limited assets and liabilities. Please follow carefully. In 235, B limited, what they will do, they go on purchasing the shares of A limited in the open market. And if it is not a listed company, come on, no control over the Companies Act. Go on purchasing shares. If one of the company happens to be a listed company, SEBI takeover guidelines has to be followed. Go on purchasing the shares of A limited and make it 100% subsidiary. And once you make it 100% subsidiary, no minority interest is involved. Now, don't disturb everything. So now B limited, their board of directors will take control of A limited. You remove those directors and go there and let them continue in A limited as well as B limited. Slowly after 1 year or so, at the end of the year, just transfer the assets and liabilities of A limited through a book entry and go for strike off of name of A limited. So in this whole process, what happens? No tribunal approval, no meetings, nothing. So this is to avoid the tribunal approval. This is to avoid the meetings. This is to avoid all the expenditure and all. Simple game plan in 235 is purchase all the shares in the open market. 100% subsidy you must make it. But then minority interest is not involved. That's all. No one's approval is required. So continue the game. Don't disturb your business operations. And by the end of the year, just transfer the assets and liabilities of A limited through a book entry. And A limited is a hollow company. No, go for strike off of name, over. But the problem is this we can do outside the provisions of the Companies Act. Why do we require 235? We require 235 because purchasing 100% of the shares is not possible. There'll be some shareholders who will never sell the shares. And unless you purchase 100% of the shares, you can't go ahead in 235. You can't go ahead in this game plan. 235 gives a mechanism which states if you purchase 90% of the shares, you can compulsorily purchase the balance 10% minority shares. That is the idea. So 235 technically starts when you already purchased 90% of the shares. That is the idea. Let's quickly run through. Now, procedure. Takeover guidelines has to be followed. First, the transferee company B limited makes an offer and it should be kept open for 4 months. And they should give a circular. It should take the steps of cash necessary available. It should be filed with ROC. Please see. The total shares capital or market value of A limited is say about 100 crores. B limited makes directly an offer to the shareholders of A limited. Hey, look, I want to take all these shares. I want to purchase compulsory shares to you. Not compulsory purchase. I want to purchase your shares. Market value is say about 75 rupees. I'll offer you 80 rupees, 90 rupees, or even 100 rupees. It should be attractive enough. So the whole game plan starts with the offer. So it should be a serious offer. And that offer letter has to be filed with ROC. And then most important is See, where are you going to get cash? 100 crores. You're not going to remove from working capital. So B Limited has to make a very serious offer. And the offer is open for 4 months. After that, what will happen? Come on, lot of transfer of shares will come from the members of A Limited. Then B Limited will purchase all the shares, pay the purchase consideration, and everything will happen. Now, if you are not in a position to purchase 90% of the shares, that's all. You cannot invoke 235. Assume that you already purchased 90% of the shares. Technically, now you enter 235. Now, what we do, the balance 10% shareholders are dissenting members. To give another notice to them, say within 2 months, I will acquire your shares at the stated price. Who is the dissenting shareholder who has not given the consent or who kept quiet? All these fellows. Now, in the meantime, the dissenting shareholders can go to tribunal within 1 month. That we should not requesting the tribunal that please don't allow this to happen. You have to prove malified intentions and all. And once the matter goes to tribunal, listen, company is not going to tribunal. The dissenting shareholders are going. So dissenting shareholder, the tribunal will give the final decision. If the dissenting shareholders wins the case before the tribunal, that's all. The game collapses. Now, what shall I do with the 90% I have? Better luck next time. But if the dissenting shareholders lose at the tribunal, then compulsorily the balance 10% has to be transferred and sold to the B Limited. That is the game plan. So how do you do that? How do you do that? By you take the blank transfer deed and you attach all the correspondence and the purchase consideration, everything you pay to the dissenting shareholder, and he will take the purchase consideration, send it to you. By that time, many of them will transfer. But still, there are some fools who will never transfer the shares. Don't bother. What the law says, you please take the share transfer form. In B Limited, the MD will sign and put the purchase consideration and all, then directly send it to A Limited, the company. And the company will exercise lien on shares, means compulsorily transfer. So they will not care the dissenting shareholder of A Limited. So the MD of A Limited will just put the signature, keep the purchase consideration A Limited, and register the transfer of shares. Now, technically, 235 is over. So 100% of the shares is transferred in the name of transferee company. Now, in the meantime, this A Limited will write a letter to the shareholders. They have gone through the procedure. The share certificate has no meaning. It's a waste document. I have already, come on, surrender the share certificate and take the purchase consideration. Story is over in 235. Now, 236 is a new section which they have introduced. What is one big drawback you find in 235? First drawback. 235 also is complicated because the dissenting shareholders can go to tribunal and get the whole game plan stopped. How to get this 100% shares? 235 is a new section. 236 is a new section. It need not be linked with 235. 236 says, if already a company or any person, acquirer, is holding 90% of the shares of a company. How did you get 90%? It may be through 235 or may not be. The game plan starts, if any person is holding 90% of the shares, a company or any person, new procedure is given in 236, wherein without going to the tribunal, you can compulsorily act balance 10%. The only difference between 235 and 236 is, in 235, tribunal approval is required. I mean, dissenting shareholders can go to tribunal. In 236, no tribunal. In a very shortcut method, 236 says the dispute is always in valuation, share value. The dissenting shareholder says, you are acquiring at 100 rupees, I want 120, 130. Fine. Go for valuation. Over. So this value or whatever value he decides, that is acceptable for the company as well as the dissenting shareholder. That's all 236. So 90% you got, then get the valuation done by the registered valuer. Then as per the valuer will give you the valuation report based on the SEBI guidelines and other guidelines, keeping all the factors in mind. Then what you do, that the person has to give the purchase, has to give the 10% the shares amount to A Limited. A Limited will keep in the bank account, and A Limited will directly purchase the shares and register the transfer of shares. This is what is this. Then 237, power of central government to amalgamate in the public interest. Over. Story is over. Central government, where the central government is of the opinion it is in the public interest, they may amalgamate 2 or more companies. In NTC Limited case, 36 public and private companies were amalgamated into single company. Public interest. That's all. Government is so powerful. No procedures, nothing. So power of the central government for amalgamation. In the public interest, they will amalgamate 2 or more companies by official gazette. And they will decide, the document will decide the privileges, rights, liabilities, contracts, name of the company, everything. How many companies you are merging, what happens, what about the employees, what about the contracts, everything that document issued by central government will decide. Usually the problem is the continuation of legal proceedings, all will be provided in the document, but usually the problem is dispute. In the pricing, the dispute comes. So yeah, the central government has to send a copy of the draft order to all the company's members and all, and they can go to the tribunal for appeal. Usually the dispute is only with reference to pricing, the compensation part of it. So every person's interest, they'll go to tribunal, and tribunal will give the final order. And a tribunal will settle the issue, and then finally the order will be given, and the central government order will be placed in both houses of parliament. That's all. This is in brief the story of compromise arrangement, amalgamation, and reconstruction. Now, special courts. You have got around 11 lakh public and private companies in India. Justice delayed is justice denied. Tribunal's role is different. Tribunal roles is only very specific in the Companies Act. But in case of prosecutions and all, it has to be done by the criminal courts. Now, in India, you go to the regular magistrate court or sessions court and other criminal courts, they handle with various other cases. So it takes years and years. So what the Companies Act says is, we are going to set up special courts, which is nothing but a criminal court. But what is the advantage of special court? They will hear only cases pertaining to Companies Act violations. That's it. So how do they constitute? Central government, for speedy trial for offences punishable under the Act, may designate lot of special courts. In Bombay, Delhi, Madras, Calcutta, they have set up lot of special courts now. And the special court will consist of one single judge. In case all who is owns as a sessions judge or additional sessions judge, and they will deal with cases of 2 years or more imprisonment. Rest of all the cases, the metropolitan magistrate, judicial magistrate of first class, that people will be appointed as judges in the special court, with the concurrence of Chief Justice of the High Court. And all the offences under the Companies Act can be tried with the special court. And they will also have liberty to try summary proceedings. Summary proceedings, shortcut proceedings. Mobile courts and all we have seen. So we'll not go into details. The facts speak for itself. Summary trial also they can do. Appeals and revisions will directly go to High Court, and all your criminal procedure code also will apply in case of special courts. One issue, offences to be non-cognizable. In the entire Companies Act, all the offences is non-cognizable, means if you want to arrest a person, the police or any authority cannot arrest without arrest warrant, except one section in the Companies Act 212. Investigation by Serious Fraud Investigation Office. In serious fraud investigation office, if after completing the investigation, they want to arrest a person, they can arrest a person without arrest warrant. So the offense are cognizable offense means police officer may arrest. So under 212 of the Companies Act, investigation by serious fraud office is a non-cognizable offense. Then non-bailable also. So one should never go and venture into that area. Next. Now, one more meaning of cognizance of offense is, can you and I file a case in the court of law? No. Who can file the case in a court of law? Criminal cases. Registrar, ROC. If you want a complaint, you file a complaint with ROC. Or shareholder or member, he can also file. Or a person authorized by central government, or SEBI can file for non-payment of dividends, transfer of shares. Then now you have got mediation and conciliation panels. Mediation and conciliation panel. Tribunals have found out in many cases which comes to the tribunal or which comes to the central government or whatever it is, it's just a waste of time. The party is only ego problem. At one point they realize, let them sit across the table and settle the issue. Hence, in the new Companies Act, they have formulated this mediation conciliation panel. Mediation is intervention of third party. Conciliation means settling the dispute of fair manner. Then the central government shall constitute mediation conciliation panel. A lot of chartered accountants, company secretaries, advocates having certain qualification experience can register themselves. So that mediation panel, during the pendency of the proceedings between the central government tribunal, appellate tribunal, they may refer the matter to mediation panel. What cannot go through the mediation conciliation panel? Any proceedings under inspection investigation that cannot go through mediation. Then offenses where compounding is done, then fraud, fabrication of document, forgery offenses, criminal offenses, cases involving public interest, these cannot be referred to mediation panel. Next. 248, strike off of name. Power of the registrar to strike off, section 248. Winding up of a company is a very elaborate procedure. It takes a lot of time, effort, money, and all that. A shortcut method is strike off of name of the company, section 248. There are two methods of strike off. One is company itself taking the initiative to get its name struck off. Second, ROC forcing the company and strike off the name of the company. Two methods. 248 subsection 1, 248 subsection 2 method. Right. 248 subsection 1. That is strike off of name by registrar. Compulsory strike off by himself. ROC itself will take the initiative. First, the company has failed to commence business within 1 year of incorporation. This business has to be understood as not commercial production, but not commercial production. You mean to say every company has to start commercial production within 1 year? No. You should do some business activity, commercial activity. For example, in 1 year after incorporation, what I've done, I opened a bank account, fine. Then I finalized the project report. Then I purchased land, enough. Next year, what you have done, I purchased the plant and machinery. I got the term loan approval from banks, financial institution, enough. Some business activity has to be done. Then they won't strike off. You just started, incorporated the company for 5 years, 10 years, just like that, it is lying idle. You're not started any business activity. It is enough ground for strike off. Second, the company started the business activity, but somewhere in 2 years, there was no activity. That's the difference in the second one. And they are not filed to get any dormant company status also. Third, they have added these 2 points. The subscribers to memorandum has not undertaken to pay. See, as I told you now, the other day I told you, now you should file a declaration with ROC before you commence the business. Both private and public company has to file the declaration for commencing the business within 180 days of incorporation. If you don't file, that is also enough ground. Fourth, the company is not carrying on business. ROC got some doubt. There is no company at all. He came for physical inspection under Section 12. There was no name board, there was no office, there is no infrastructure, there's no furniture. After he is revealed by physical verification, then he can take the initiative to strike off. One is, within 1 year, you did not commence your operation. Second, you stopped your operation for 2 years or more in between. You did not file the papers for commencement of business. And fourth one, there was no activity on the as physically verified by ROC. These 4 circumstances. Then in that case, ROC will send a notice to all the directors, STK 1, by register post, intention to remove. Notice will contain the reasons and all. These are procedural aspects. Come to second method. Strike off of name on application of the company taking the initiative. The registrar can strike off the name of the company on the basis of application. Most important point is there must be no liabilities. If you want to take initiative, but when ROC takes the initiative, that is not the criteria. You yourself are taking the initiative, there is no liability. That means in the liability side in the balance sheet, you can have share capital, reserves and surplus. In other words, in the secured loans, unsecured loans, current liabilities and provisions, nothing should be there. And reasons are almost the same. Company has not filed 1 year of incorporation. They have stopped the business for 2 years. They are not filed the commencement of business. And fourth one, the physical verification revealed. So in these cases are the same 4 cases. Now restrictions. An application shall not be made any time in the last 3 months. If the company has changed the name, you have shifted the registered office, or you disposed of the properties, there are a lot of restrictions. You should not do it. Or engage in any other activity. These are the restrictions. Or a compromise arrangement proposal is pending. You give time for it to, or the company is already started winding up under IBC, you cannot file an application. Then the company will be notified as dissolved after they accept it. You can go to appeal to tribunal within 3 years for restoration of name. Then ROC will restore. Then application can be made for restoration by all these people. Within 20 years also you can go. So then these companies' names cannot be struck off. Listed companies. He has looted thousands of crores of rupees money from the general public. How many companies are there? They sold all the assets. It's a hollow company. They call the consultant and say, come on, go for the strike off of name. No, not possible. Second one, delisted. It was a listed company. It was later delisted because you are not complied with the listing agreement. They cannot go for strike off name. Vanishing company, shameful for us. I checked up the Oxford dictionary. There is no such meaning called vanishing company. Gone, poche, poinde. This Amurthanjan advertisement, you know, Amurthanjan advertisement. They just apply the Amurthanjan and say, gone in all language. Where gone? Shameful. It will happen only in India, not in any other country. 2,000 listed companies. They have looted public money left and right. Each looting about 5 crores to 10 crores to 50 to 100 crores. 2,000 listed companies, the rest, and the SEBI files a report stating that most of them in the old Companies Act, that the directors are not traceable. There is no registered office. See, shameful, isn't it? Where it has gone, corruption to this extent in this country, ethics, values, everything has gone wrong. Vanishing companies. They cannot go for strike off. And then companies where investigation is being ordered, prosecution of offense is pending in the court, or compounding offense that application is pending, they cannot be ordered. Then this default in the repayment of deposit, charges are pending, and Section 8 charitable institution, these cannot go for. Now, punishment for fraud. We have used a number of times Section 447. You can be punished for fraud. What exactly is this Section 447? If your person is punished guilty of fraud, amount involved is 10 lakh rupees, just 10 lakhs or more, or 1% of the turnover, whichever is lower. They are classified frauds into two categories for the purpose of punishment. The amount of fraud is 10 lakhs or more, or 1% of the turnover, whichever is less, imprisonment not less than 6 months, minimum 6 months, which can go up to 10 years. And also liable to fine not less than the amount of fraud, which can go to 3 times the fraud. In respect of other frauds, and if it involves public interest, minimum instead of 6 months, it is 3 years, 3 years to 10 years. If the fraud involves less than 10 lakhs of person and does not involve public interest, maximum punishment is imprisonment up to 5 years and fine which can go to 50 lakhs or more. These are all inserted, the new provisions in the Companies Act 2013. We find almost in 18 sections that if you do this, you are punishable as fraud. This is the punishment for fraud. This is one specific section, height. Punishment where no specific penalty punishment is provided. While in most of the sections, they have given the penalty also, there are many sections. If you don't go with the board meeting, what happens? Like that, there are so many 100, 150 sections where they have not given the punishment. If you violate any of those sections, the punishment can go up to 10,000 rupees fine and continuing contravention 1,000 rupees per day. So this general penalty section 450 will apply. I will now move to winding up of companies. I remember one joke which had come in a Chartered Secretary magazine. The interview for the company secretaries was going on. Managing director called a candidate and said, "Are you thorough with all the provisions of winding up? Are you thorough with all the provisions of the Companies Act?" That guy replied, "Yes, sir, except the provisions relating to winding up." Oh, I see. Why you are not studied winding up? Sir, you mean to say I will stay in your company when it goes for winding up? So I see most of the people forget this winding up. After all, winding up does not happen on daily basis. And the winding up again is a lot of specialization, lot of procedures are involved. My object in touching winding up of companies in this session is, for about half an hour, is to tell you what are the circumstances, what are the role, who can do what. A overall discussion only about the winding up of companies. As you know, what is the meaning? There are 3 words. We often confuse with the 3 words. Liquidation, winding up, dissolution. These 3 words are not interchangeable words. Liquidation has a different meaning, winding up, dissolution. Liquidation means the order passed by the court in compulsory winding up. The company is liquidated, or resolution was passed for liquidation. Then winding up is a process. In winding up, what happens? Come on, the legal entity will continue. In winding up, what happens? The liquidator comes into picture. He sells all the assets, pay off the liabilities. The legal entity continues. Then the directors, auditors role come to an end. Liquidator is the controlling authority. Winding up, the legal entity continues. Dissolution means the legal entity comes to an end. So these 3 words are not interchangeable words. The whole process starts with liquidation. Winding up is a process. Then dissolution, it ultimately comes to an end. Modes of winding up. Now, a lot of changes have taken place in the Companies Act. Winding up is of basically 2 types, compulsory winding up, voluntary winding up. Now, many of you know Compulsory winding up by the tribunal alone is now governed in the Companies Act 2013. Voluntary winding up, whether they solvency or insolvency, have been shifted to IBC from 2013-16 onwards. So I repeat, voluntary winding up of companies, whether you have solvency or insolvency, both cases, it has gone to Insolvency Bankruptcy Code. So our discussion is only focused for compulsory winding up under the Companies Act. What are the circumstances? In the new act, those circumstances are totally changed. One, the company itself takes the initiative. Whether it is solvent or insolvent, sir, why not the company go through IBC method? No. There are many cases where the pressure from the creditors, debenture holders, deposit holders so much, the members find it very difficult, directors find it very difficult to wind up. So they may go for compulsory winding up, requesting the tribunal, please wind up by yourself. Second, these are new points introduced. Against the sovereignty, integrity, and friendly relationship with the state, public decency, morality. What is all this? Then what is all this? They are social parasites. We don't want these companies to exist. It should be wound up. Government will take serious actions, smuggling companies, these companies, public, they interfere with the good relationship with the foreign countries. You do a lot of mischief, you avoid the taxes, you do illegal things. So power is vested with the government to wind up all those companies. Third, application is made by registrar. We discussed in operational mismanagement case, in investigation, the matter will be referred or they will wind up. Now continue there. Affairs are conducted in a fraudulent manner, unlawful manner. Persons engage the management, they're guilty. So registrar will make an application for winding up. Next, default in filing the financial statement annual returns for 5 years. We saw in disqualification that for 3 years you don't find annual financial statement, annual returns. No, directors will be disqualified. For 5 years and you don't file, it is enough grounds to wind up the company. Then just and equitable grounds. So these are the 5 different grounds on which you can go for winding up of the company. So grounds on which they may be wound up, just and equitable grounds, they're all based on case laws. What 2-4 issues I'll tell you. No existum generis means, is it any just and equitable ground or just and equitable ground similar to the preceding grounds? There is no existum generis, means any just and equitable ground. Then why did you give the 4 grounds also? We only gave examples to impress upon the tribunal that these are also cases which will justify winding up order. So it could be just and equitable grounds, means not necessarily the 4 grounds, any ground. Second, they are all based on case laws. Object is fraudulent, deadlock, object is achieved. Complete deadlock in management, private company, 2 members and 2 directors, each holding 50% shares. They are not in talking terms. Company is a bubble, no business to carry on. They're all just and equitable grounds where you will wind up. Disappear substractum. Suppose the government has nationalized the particular object which the company was doing. It was impossible to carry on the business except at a loss. The idea of doing business is not at a loss. Go for compulsory winding up. Lost result. In many of the cases which come to the tribunal, winding up under just and equitable will be a last resort. Tribunal will fight to find out, do you have a remedy under various other sections? If so, they will not order the winding up. And the 4th point they keep in mind is public interest. They are providing employment to various employees. They are paying taxes to the government. So many issues are there. So as far as possible, the tribunal will go for revival. So winding up is a last resort, and public interest factors also will be kept in mind before we do the winding up. Who can file the case for winding up? Company. Company means board of directors, only for the first reason, that is filing the special resolution they can file. Second, contributory. Contributory is nothing but equity shareholder of the company whose name appear in the register of members as on the date of winding up. That means you are nothing but the shareholder of the company, but you should not sell the shares. So you are called as contributory. And which contributory shares were originally allotted to him, or in the last 18 months you must hold the shares at least 6 months, or the shares was given to him because of transmission. So then only you will be eligible to file the winding up. Legal representative is also contributory, all this. Government, when they can file the case for winding up, only in the national interest. We saw the second cases, those cases government can file the case. Then also this. Then ROC. ROC, of course, previous approval of the government is required. ROC, what cases? Business carried on for fraudulent, unlawful purposes, all that, those cases. These people only can file. I repeat, company, contributory, central government, ROC. And a copy of the petition has to be forwarded to Registrar of Companies. And the ROC will have to give the views to Tribunal. See, those days, winding up used to take terrible time. Now all that is gone. Now those things are not there. Now time limits. Filing of statement of affairs. If any application is made to the Tribunal, other than company, means what? Contributory, ROC, central government has made an application, the company should file statement of affairs within 30 days. Tribunal may allow further period of 30 days in special circumstances. Statement of affairs. And if the company does not file statement of affairs, their right to object will go away. What is the statement of affairs? It is something like balance sheet. It contains more details than that of the balance sheet. What are all the assets of the company, where it is located, what is the market value, breakup of all the assets, land, various breakup, plant and machinery, buildings, investments, and stock details. Similarly, the liability, shareholders details, debenture holder details, are all statement of affairs. In the old Companies Act, it was there. 25 years over, statement of affairs also not submitted. 30 years, 40 years, statement of affairs not given. Why they don't give the statement of affairs? You all know, in a winding up, who loses? Really, who lose? Public shareholders will lose. Banks, financial institutions will lose. Creditors will not lose. They know how to get their money. Promoters are the looters. They loot the money. So they don't file the statement of affairs to enable the liquidator start the winding up proceedings. I'll just share a joke. It is not a joke. It is a very serious issue. Just 2 minutes. One company, High Court, I was attending the case. No details, no names. 25 years. Statement of affairs not given. Judge was shouting. Judge said, silver jubilee is over. It's a private company, 2 members and 2 shareholders. I'm postponing the hearing by 1 week. Within 1 week, if you don't give, it happened in Andhra Pradesh only, Hyderabad. 1 week, if you don't give the statement of affairs, call out both the shareholders. I'll straight away give them 2 years imprisonment. Then our case came. Our case also, that anger was felt. Leave it. The next week, I went once again because our case hearing was also there. Their case also came. I was very excited because that advocate, I know him. I went and asked him, hey, statement of affairs ready? Hey, gentlemen, keep quiet. What keep quiet here? This is a public hearing. You know what happened on that day? Shocked my conscience. When the hearing started, judge said, where is the statement of affairs? The advocate gave 2 certificates. The judge saw death certificate of both the shareholders. Somehow he managed. He got the death certificates of both. Judge was laughing. By the time they managed the official liquidator, then judge was asking, come on, is there any assets, liabilities? Only private company. No, sir, nothing is there. Swaha. Judge straight away gave the winding up order. Judge was joking. Oh, both of them died. I see. At a time they died. Oh, this fellow died because of pneumonia. That fellow heart attack. Then the proceedings was over. The advocate called me. I went to the gate. The two fellows are standing there. Will it happen in any country other than India? Can a person roam around having death certificates in his pocket? Now he can do crime. He can do crimes. I used to tell, because this winding up is all boring. So in all my lectures to my students, I used to tell all this. Mostly I used to tell in CS classes, but some CS students also attend my class. Once what happened, a friend of mine, a very close friend of mine, no names and all, he was correcting CS final papers. He suddenly telephoned me one day, Jaraman, come to my office. He said, very urgent, come to me. I rushed to his place. He showed one paper to me. What is this here? Why you are showing? No, read it. That student has written, a question was regarding statement of affairs. He wrote all the answers. The statement of affairs contain all the details is to given. Then he wrote last paragraph. All this is bogus. What happens in the reality is totally different. Death certificates are produced in the court. Whatever I told in the class, he has written. Then my friend looked at me and said, you are the only guy in the whole India who will give this example. See, that fellow has written. How much you are influencing the student here? I said, I don't know anything, rather. See, reality is something totally different. Let us read only theory. Of course, now things have changed. Now IBC has come. Now all this, our people have come insolvency professional. I'm only trying to tell those days, he is talking 30 days, 60 days, 25 years, 30 years, statement of us not filed. It was pending so much in the courts. Anyway, I thought I should just tell you. So 30 days. And then tribunal. Then the petitioner has to deposit the cost and all. That's what I told. If you don't give the statement of affairs, the company will lose the right to petition. Apart from that, now what is he saying? The directors and officers within 30 days of winding up order submit all the books of accounts. Everything has to be given to the tribunal. Then for speedy administration of justice, we require. Then what is this provisional liquidator? What is this provisional liquidator? See, the ROC or contributory, except the company, central government has filed the petition for winding up. They filed with the tribunal on 1st January. Tribunal may take some time, maybe 30 days or 60 days or more than that. But in the meantime, once the general public come to know that this petition has been wound up filed for winding up, hell is broken loose. They come to the company, loot the registered office, loot the factory, free for all. Computers, tables, chairs, machines, everything is taken out. Board of directors say, I have no control. So the concept of provisional liquidator. So when other than companies, someone has filed a petition for winding up with the tribunal, on the same day, the company will say, sir, there's a possibility that the assets will be damaged and taken away. So I want you appoint one person, the official liquidator or the IBC fellow as provisional liquidator, to take control of the assets. The only one function of the provisional liquidator is let him come to the registered office, seal the registered office, seal the factory with police protection, so that he does. Then thereafter you take your own time. So then the tribunal will appoint a provisional liquidator. The only function of provisional liquidator is to take control of all the properties, assets, and records of the company. After receiving the winding up order, making the provisional liquidator can also be appointed under IBC also. They'll give notice all that. Now, and after winding up, he himself will continue as the regular liquidator. And one important point, if the company is objecting the appointment of provisional liquidator, the tribunal will not encourage the application, because tomorrow if they don't make the winding up order, the whole company comes to a standstill and it was locked for so many days. So only when the company itself wants the provisional liquidator, he'll be appointed. Now, appointment and removal of liquidator. I want this point to be told. Liquidators now are of two types. One is official liquidator. You all know in every state there will be two officers. One is the Registrar of Companies Office. Second is official liquidator office. Official liquidator will take up all the liquidation cases and he will function under the direction of the High Court. Now under the direction of the Tribunal. Now what they did in the IBC is, how many official liquidator offices there in each state it is? And they've got an office of just a staff of about 20-30 people. Thousands and thousands of cases are pending before them. And that is one of the reasons for delayed winding up for years together, which is happening in the country, years together. So what the government has done, chartered accountants, company secretaries, cost accountants, one examination is conducted. You pass that examination, specified marks, then you become insolvency professional IP and you can be appointed as liquidator. Marvelous achievement of BJP government, IBC, Insolvency Bankruptcy Code. So now, once this IBC goes on, maybe in another 5 to 10 years, the office of official liquidator will be abolished. So insolvency professional only will take care of the winding up with lot of responsibilities under code of conduct and all. So who can be appointed as liquidator now? Compulsory liquidator, either official liquidator or liquidator under insolvency bankruptcy code. So, but I understand now compulsory winding up very big companies is given to official liquidator, but otherwise lot of IBC people are also doing the winding up proceedings and all. Then appointment, you have to disclose the lack of interest. Discharge of employees. Once the winding up order is given, it will automatically act as termination order for all the employees. And one winding up committee is going to be constituted to assist and monitor the winding up. See, as of now, this company's liquidator, the insolvency professional may not have that much experience. So what they will do, they'll keep a winding up committee in which official liquidator, one nominee of the secured creditor, another professional appointed by tribunal, and this fellow, the insolvency professional will be there. So these people will monitor the winding up or monitor the functioning of the insolvency professional also. Then stay of suits. That is, once the tribunal announces compulsory winding up, all the existing suits will stop. Second, all the existing suits will be transferred to the tribunal. And third, fresh suits can be taken up only by the tribunal. Otherwise, what happens? Every court encourages suits and all, it disturbs the winding up process. So these are the effects of winding up. Then report by the liquidator. Now, once the statement of affairs have been submitted, the next issue will be within 60 days of the winding up order. Then similar like statement of affairs, a report will be given by the liquidator to the tribunal, giving all these details of assets and all. The idea behind the report is, now the tribunal comes to a conclusion, oh, this is the financial position of the company. So if the liquidator sells the assets, this much he will get, this much liability. So after the report is filed, the liquidator will start his work. And books of accounts to be kept by the liquidator. One, not different ledgers, only one cash book he has to keep. And every year, from the date of winding up, twice he has to submit the report to the tribunal, all that. Then it is open for inspection. One, you have to file with the registrar and all. Arrest of person trying to leave or abscond. These are some provisions you should know. So either before passing the winding up, a tribunal has satisfied the contributory having property, all this is trying to leave India. Then they, for evading the payment of calls and all, they can arrest even the members. Those who are not going to pay the call money or run away, the tribunal has got powers and seize the books, papers of all such people. Then secured creditors. So secured creditors who has got a mortgage. So secured creditors, what he has three options. Option one is, first option one is, if the security is adequate, take the security and forget the winding up process. If the security is inadequate, second one, then you take the security. For balance, you stand in the queue of unsecured creditors. Third one, they have got a security, but useless security you have got. So you can relinquish your security and stand in the queue of unsecured creditors. This generally happens, when the unsecured creditors are getting about 80-90%. Secured creditors feels these are all encumbered securities. It will take a lot of time. So you may relinquish all the three options he has got. Now, order of payment of debts in MIDICA. First, a secured creditor has to pay liquidate or expense secured creditors, workers' dues. I'll come to that. Then preferential creditors, floating charge, then unsecured creditors, then preference shareholders, equity shareholders, surplus will be divided. But one important point I want to tell you, who are the preferential creditors? Who are all the preferential creditors? Revenue, cess, taxes, rates payable to the government or local authority 12 months prior to winding up. Hey, all the income tax, sales tax due for 5 years are not preferential creditors. Only which is due, cess, rates, taxes to the government or local authority 12 months prior to winding up is only preferential creditors. Then salaries and wages to the employees 12 months prior to winding up, in that 4 months not exceeding 20,000. So every due to the is not preferential creditor. Once you do one winding up, you'll know all this. Then holiday remuneration, that means what? This leave encashment, everything is preferential creditor. Similarly, employers' contribution under ESI, PF and all, 12 months prior to winding up. Then expense of investigation, then Workmen Compensation Act, then ESI, both the employer and employee contribution, they are preferential creditor. Now, out of the list of the preferential creditor, whatever due to the workers are there will be called overriding preferential creditors. It is also called workman dues. Right. Now, a new rule. This is what I want to tell you. The new rule, please see. When on the sale of the assets of secured creditor, the amount realized is not sufficient to pay the secured creditors and preferential creditors in full, the amount will be proportionately distributed between secured creditors and overriding preferential creditors. Not secured and preferential creditors. It will be proportionately between secured and overriding preferential creditors. Fraudulent preference. Normally, when you pay to the creditor, nothing wrong. Payment to the creditors. Debtor-creditor relationship. What is fraudulent preference? Payment to the creditors now in this circumstance is void, fraudulently preferring a creditor. What are the fraudulent preference is void? First, what are the conditions for fraudulent preference? Before winding up, 6 months before the winding up, whatever payment made to the creditors will be fraudulent preference. Second, it is to prefer the creditors. That means what? It happens only in insolvency situation. If everyone is going to get the payment, no subject. Then it's a voluntary act. Of course, there's no court order. It's a voluntary act. And fourth one, it relates to money, delivery of goods, transfer of property, anything is fraudulent preference. Fraudulent preference is void. The liquidator will ask them to bring back all the money. If this point is not there, what happens? Come on, the board of directors know they are going to go for a winding up. They will sell all the assets and pay off everything, and the creditors will not get 1 rupee also. Similarly, transfer of goods, any sale of goods in the last 1 year prior to winding up is void. Of course, those made in the ordinary course of business in good faith for consideration, they are not void. So in simple sentence, what do you understand? All the sale of goods made in the last 1 year prior to the winding up for inadequate consideration is void. Similarly, transfer or assignment to the benefit of the creditors, they're all void. What is this? Transfer or assignment of property in benefit of the creditors is void. The creditors are saying they don't have trust in the liquidator, they don't have trust in the board. What they are saying, all the assets you give it to us, we'll form a trust, nothing doing. The very purpose of winding up is you have to follow the procedure, what is given there. It has to be. Effect of floating charge. See, creating floating charge is very easy. Just to take a document, fixed charge is difficult. So unscrupulous floating charge, if you create, it will affect the unsecured creditors. So what he is saying, all the floating charge in the last 12 months is void. However, two exceptions. Floating charge is not invalid when the company is solvent. I'll give an example. Please see. The total miscellaneous assets of the company is about 2 crores. Sorry, the total unsecured creditors are 2 crores. Some miscellaneous assets are there, 1 crore. If the company goes into liquidation, these unsecured creditors will get 50%. Now, out of this unsecured creditor, one dominant creditor to whom 1 crore is due, what he can do? He can purchase AK-47 rifle and put it on the head of the managing director and say, come on, I know that you are going to go for winding up, just to create a floating charge before I pull the trigger. MD does. This is unscrupulous floating charge. So tomorrow when the company goes into liquidation, come on, this fellow will get the priority and the balance creditors will not get anything. So what he says, all the floating charges created in the last 12 months is void. Now, what is the exception? Floating charge is not invalid if the company was solvent. So banks, what they do, you have to genuinely protect the bank which has created floating charge even the last 12 months. So that's why bank will say solvency position. At the time of creating the charge, the assets will be more than liabilities. But there, that unscrupulous creditor, how he is not protected? Because he gave the credit long back. So at the time when he gave the credit, at the time when the charge is created, insolvency position is already created. Similarly, floating charge is valid. What he is saying, that you create a charge and give a loan, then the loan plus 5% is valid. Even if there's insolvency position in the last 12 months, what he is saying, to protect the banker, you create a charge, give a loan, then the loan plus 5% interest is valid. Unscrupulous creditor is not protected because he gave the credit long back. The charge was created now. So in this way, these floating charges are also regulated. So thank you very much. We had a wonderful session. To the extent possible, I think I have done justice to this. My only one advice to the participants will be, please update yourself. I've seen in the last 11 days, almost 11 days, 22 hours, I've taken the session. And I'm very happy that I took this session for all the qualified chartered accountants. Then from the feedbacks and reports which I get from all of you, I'm so happy, and terrible feedbacks I got. And the one point which I would like to tell you is, knowledge alone is power. Once we become chartered accountants or company secretaries, it's not the end of the story. It is the beginning of the story. So please, you have to spend 1-2 hours daily. Come what may. Make it as a practice. Take one chapter, any law, income tax, GST, Companies Act. Come on, you have to revise, you have to update your knowledge. Otherwise, in a competitive world today, you'll be thrown out. Many cases I've seen, professionals making mistake, it is shameful. One black sheep can destroy the entire profession. That's what I've seen. So my humble request to all of you will be, update your knowledge. God has put you in the highest pedestal. You are all chartered accountants in this country. So therefore, let us tighten our belt. The concept of free lunch has gone. What has happened yesterday, let us forget. Now let us concentrate. The society expects a lot from us, ethics and values. And life has taught me, as I've told earlier, 99 correct things you do, no one appreciate. One mistake you do, you are shown the dose. I know today you may be signing a lot of reports here and there. Doesn't matter. By mistake, if you are signed not doing your work properly, terrible consequences are there. Public gives us no sympathy as such. So thank you very much. I once again thank the chairman, particularly Mr. Srinivas Rao, for giving this great opportunity, who has been very cooperative with me. And it was lovely for me to share all my experience and the great patience all these chartered accountants had hearing. Thank you once again. Thank you one and all. God bless you all. Thank you, sir.
Thank you, sir. Thank you very much. Really, really a wonderful statement. We are really honored to be here, sir. Your presence make all the difference. The kind of info that we are getting, the kind of appreciations that we are getting in the WhatsApp groups and also mails. I think in the morning I have forwarded one mail. His daughter is your student and he is attending the classes. See-through changes in his life. In the last 33 years, he has not experienced such kind of a thing when a person of high caliber continuously non-stop at a same pitch, he is able to tell the things in such a way. And he also commented on that. What is the background work that you are doing before telling this session? Every day in, day out, because even if you want to give 2 hours lectures, almost 4 to 5 hours you are just reading for the refreshing the things, though you are doing in the subject also. Like, that is the kind of commitment that you are showing to us. Thank you, sir. Thank you very much. We are really honored.
Two things I would like to tell. Sorry for the interruption.
Yeah.
One is, how I was able to come to this level. So actually, 40-50% of the subject only I take for inter, another 40% for final. For that, I take 120 hours. So I go very slowly with lot of jokes, practical experience, all that take the students. But here the time is very short. And pure theory, if I tell also, it is not interesting because chartered accountants already know. So I had to make a mix of theory and practical examples and go a bit fast. So I know some of the areas have gone a bit fast and all that. But students and all, I'm very happy to tell you that though this 1 lakh students, out of which at least for 10 to 15,000 chartered accountants in South India might have studied law under me, and there was some experience which I would like to share, which gives the purpose of life for me to be served, is some of the big four and also some of the top companies there. The chartered accountant firms have telephoned and told me, sir, in the interviews, when we interview for articles and other posts, when we ask some question, they answer it. Then immediately we get a doubt. Where did he go? How he is able to answer? They ask, did you attend Jayaraman sir's class? Yes, sir. Then that gives me a lot of confidence. They told me, Jayaraman, the way in which you approach the subject, it gives a lot of confidence to the students. This is what it is. We have to put it this way, not overall reading of the subject, because the client expects you have a deeper understanding. First one. Second one, as I've already told you, from December 16, 17, 18, the 3 days in December, I will take up those areas which are relevant for public companies. I will, the same thing, 99% applies. What I discuss for private company only applies to public companies, but some new areas like prospectors, then the various committees, various other small topics which are there, those 3 days I will cover. Oh, sir. Yes. Yes, sir. What?
Thank you, sir. Thank you very much. Really, that's a wonderful thing that what you are telling, because last night and today morning also, I have received a mail saying that we are residing at Lucknow. We would like to join the Vijayawada branch enrollment. We would like to be a member of the Vijayawada branch. Those things, that requests are coming only because of you people, sir. Really great. Thank you, sir. Thank you very much. I request all the delegates, really wonderful participation. Today being the last day, though it is the last day, it is more than 100 members participation today also. Thank you, sir. Thank you very much. I request everyone, don't miss this public limited companies classes, which is going to be conducted in December 16, 17 and 18. Thank you, sir. Thank you very much. We are waiting for the same, and we'll waiting for the some more classes in the January or February. Thank you. Thank you,
Thank
Manoj.
you. Thank you. Thank you.